before we get to today's episode, don't forget to sign up to the book at thehighestandbestuse.com. That's where you'll find all of the links on where you can buy it. Amazon, Chapters, Barnes & Noble, all these places. You can get it there in ebook, paperback, and hardcover. So however you like to consume content, it is there for you. Now, on to today's episode.
I'm Bob Aaron, and the highest and best use for my business is property law in Ontario.
Thanks for tuning into the Highest and Best Use Real Estate Podcast, where we talk about techniques to optimize your land, structure, skill sets, and time, as well as the highest and best use principles to make your business more profitable, productive, and efficient. I'm your host, Ryan Carr, reminding you that good deals are found, great deals are created. And my guest today, oh my goodness, Bob Aaron is on the show. Bob, thank you so much for being here.
Thank you for inviting me.
Oh my goodness. Okay, so a couple quick points about Bob. I read your bio, and I'm thoroughly impressed. So here we go. Sole practitioner at Aaron & Aaron in Toronto. He's a certified real estate expert by the Ontario Supreme Court, also an expert witness, and he's written over 800 articles for the Toronto Star on property law. Like, Bob, you are very decorated. You are very, very well decorated.
Thank you.
Holy smokes. Thank you for being here. I'm really excited to have you. So let's kick it off with a few questions. The topic for today's show is a little bit of a mixed bag, which is really exciting, actually. We're going to talk about power sale. We're going to talk about title infractions. And then we're also going to talk about air rights. So why don't we kick it off with maybe where the current state of the real estate market is at. And before so, please introduce yourself.
Okay, so I'm a Toronto lawyer, but that doesn't mean anything anymore because nobody goes to visit their lawyers. So I've had Zoom meetings for signing purposes with clients in Australia, Europe, South America, and of course, and United States and Canada. So it doesn't really matter whether my clients are in the building next door or the halfway around the world. The only problem I have when I'm meeting with clients in China, like I did last week, or Australia, like I did last year, is I don't know what date to put on the documents that we're signing because they're on a different day on the other side of the divide, and we just randomly pick a day. So all right, so I do real estate deals, power of sales. Landlord and tenant, business ventures. I do a lot of they call it solicitor work. That is non-court work.
Right. Excellent. And how many years have you been doing this for?
Oh, you don't want to know. But it begins with a 50 years.
Yes, that's the voice of experience speaking. I love it. So why don't we just talk quickly about where the current state of the real estate market's at before we dive in here. What are you seeing in the market right now with the downturn in the last
Well, I see things that have gone, the volume in Toronto is dead. And I see that elsewhere. People aren't buying, people aren't selling, people aren't getting mortgages. It's very quiet. But I see today that inflation has dropped a little bit. I know this won't be broadcast till maybe the spring of 23, but from my viewpoint, inflation has cut down, and hopefully the Bank of Canada will start easing interest rates, or at the very least, not increasing them. And maybe by the spring of this year, we will be seeing an uptick in builder deals and in ordinary people buying and selling. We're bringing in several 100,000 people a year to Canada as immigrants. They got to live somewhere, and there's a pent-up demand. So the market can't be slow forever.
That's true. Do you believe that there is a lack of supply as an underlying fundamental in this market?
It appears that there is a lack of supply. Right now, sellers don't want to sell because they're worried about what they're going to get. But and rather than a lack of supply, I would call it a pent-up demand. So there's more demand. Sometimes it's active and sometimes it's quiet, but there's a great demand, and the demand's only going to get stronger when we have 400,000 people a year coming into this country, and a lot of them right here in Ontario.
How many people would you say on like a density basis live in each dwelling unit that they construct on average throughout the GTA? Do you know?
You mean new buildings?
Yeah, new buildings. So if somebody puts up a building, whether that's a single family or a condo unit, if you averaged everything out, how many people live in like a per dwelling unit basis? Do you know?
My guess, and this is based on nothing but my experience, is 2.5, and I would really like to meet that point 0.5 of a person.
Very true. So this leads us into power of sale. So let's talk a little bit about power of sale. What does power of sale mean, first of all?
Okay, so when you get a mortgage, you promise to pay to the bank, the trust company, the credit union, or a private individual, the principal and interest, and the taxes, and so you have to make your monthly payments. If you go into default, the lender has certain rights. They can come after you in a court for the arrears. They can try and foreclose your interest in the property, which means that you have to do that in a courtroom, and the court will award the lender ownership of the property, and you're cut out. All your equity is gone. That's not very popular. It's not used a lot in Canada. And the other important right that the lender has is to sell the property under the rights in the mortgage. And that the right is called a power of sale, the right to sell the property out from under the owner. And in Ontario, the procedure is for the lender to send a registered letter to the owner and to any parties on title behind the lender in priority, like a second mortgagee or a judgment creditor. So there's a notice that goes out by registered mail addressed to those parties, and it says, take notice that your mortgage is in default. Here's the amount: principal, interest, taxes, costs, insurance, and if you don't pay within 35 days, we will sell the property out from under you. And then the property, once the 35 days are up, the lender has the right to list and sell the property. Lender has to sell it at fair market value. Lender has to get appraisals to make sure it's fair market value, but the lender can sell the property. If there's a deficiency, the lender can sue the owner, the borrower, for the shortfall. And if there's a surplus, the lender has to refund it to the second mortgagee, subsequent encumbrances, and then the owner in priority. And that's they're all paid off in priority. The problem with the power of sale is if you're dealing with vacant land, or if you're dealing with a cottage where in the winter where nobody's there, it's easy to sell under power of sale. But if you're dealing with a property that people are living in, the problem is you got to get rid of the owners, and if they don't want to move voluntarily, the lender, which they never do, the lender is going to have to take them to court to get what they call an order for possession of the property, to physically, literally evict them. So to get an order for the sheriff to come and lock the people out.
Is that different than the landlord-tenant board?
Yeah, it's the landlord-tenant board is a board. This is done in superior court where a judge will say your mortgage is in default, you don't have a defense, you got to move out. So the lender, the mortgagee, will be given the authority to issue what's called a writ of possession, which is a court order to vacate the property. And that writ is then handed to the sheriff, who acts on it to kick the people out.
Gotcha. Now, in terms of from Canada to the U.S., the Americans have something called foreclosure. Do we have that here in Canada?
Yeah, we have foreclosure.
What is the difference?
The difference is power of sale can be done, aside from kicking the owners out. Power of sale can be done by registered letter and then by just selling. Foreclosure in Ontario has to be done by court. It has to go to court. And then if the owners dispute it, the court proceedings can take a year, 2 years, 3 years. Americans also have foreclosure. It's a different process, but it's the same sort of thing. The lender gets the right to own and sell the property.
Why would they change the name of power of sale versus foreclosure, like on a technical basis, if effectively you end up with the same result?
Well, no, you don't end up with the same result. In a foreclosure in Ontario,
Mm-hmm.
the lender ends up as the owner of the property. They get a deed to the property.
Gotcha.
Under power of sale, the lender, the mortgagee, has the right to sell the property to a third party, but not to take ownership.
Understood. Okay. So,
Lenders don't want to become, in Ontario, lenders don't want to become the owner of the property, Brian. They just want their money and they want out.
what would the purpose of foreclosure be? Somebody actually wants to own the underlying asset. Would that be the case?
Sometimes a lender will want to become the owner if there's absolutely nobody out there who wants to buy it. If it's an oddball piece of land, if it's a factory, if it's a manufacturing facility, if it's a piece of vacant land way up in the boonies, and there's no way that anybody's going to want to buy it for the next 10 or 20 years, then the lender will want to own it. The other reason the lender will want to own it, and I've actually seen this, if there's a mortgage of, let's say, $500,000, and the place is worth $1 million, and the owners do not object to the foreclosure, the lender, mortgagee, takes ownership of the property and scoops the equity. Because they've got $1 million property for $500,000, they get the profit.
Wow. And is it the same, like if you default on your mortgage, would it be the same right as a mortgage holder to foreclose or go power of sale at your discretion?
Yes.
Very interesting.
Foreclosure can take 2-3 years if to get through the whole court process.
Gotcha.
And if you think that the borrower is not going to fight you, or is dead, or has disappeared, or has no interest in the property, or doesn't want to pay a lawyer, sure, go foreclosure and see if you wind up owning the property. But if you've got a sophisticated borrower who goes to legal aid and gets some good advice, foreclosure is just going to wind up in a stalemate. And then the property is going to have to be sold under power of sale, which is without going in front of a judge.
Total timeline from end to end on a power of sale or a foreclosure, but primarily power of sale. What is the expectation at this current state of affairs?
Well, power of sale is 35 days notice, plus whatever time it takes the owner to vacate. So they could say, here's the keys, we're moving out. Mm-hmm. That's done, even while the 35 days notice is running. Or they could force the lender to take them to court. And that could take 6 months, a year and a half, while the court process slowly winds down. Mm-hmm. When the borrower says, well, I'm not really going to move out. So if you want me out, you're going to have to force me out.
Total cost to go power of sale on a borrower?
The lawyer's fees on a power of sale, which will be added to the amount of the mortgage, $2,000, $3,000, $4,000, $5,000, depending on how much work is involved in, particularly kicking the owner out of the property. Mm-hmm. And then acting on the sale of the property. There's more paperwork on a sale under power of sale. It's an ordinary sale, but there's a lot of paperwork because the owner isn't selling it. The lender is.
Gotcha. And would that $2,000 to $5,000 typically include like court costs and things like that, or would that be in addition to?
No, that's plus the court costs to take the owner to court, which could be, I don't know, $10,000, $20,000.
I was going to say, so if somebody was to go power of sale, you could reasonably expect to spend over $20,000 to get that person to sell.
Right, but presumably there's an equity in the property. Mm-hmm. Such that the lender, it's not really coming out of the lender's pocket. It's coming out of the equity, and the lender may have to front the money, but we'll get it back later when the property sells.
Understood. Are you seeing more foreclosures in the market now?
There's no foreclosure.
2 years ago?
There's no foreclosures now. There hasn't. I haven't seen a foreclosure in years.
Are you seeing more power sales in the market now?
It's starting.
Ooh.
It's starting.
Okay.
It's slowly starting. Of course, power sales are not public like a foreclosure is. Foreclosure is filed at the court, and the court records are open to the public. Power of sale is done. I mean, I've conducted powers of sale, and nobody knows about it until it's listed.
Mm-hmm.
And even on the listing, the bank or the private lender does not have to put on the MLS, this is a power of sale.
Oh, they don't have to disclose.
No, no. In fact, I advise my lender clients, don't show it as a power of sale because it'll bring out all the bargain hunters.
That's right.
Just say that there has to be a Schedule A, which the purchaser, offeror, will see at the last minute and realize, oh, it's a power of sale.
Gotcha.
But
Now with
I wouldn't advertise it as a power of sale, Ryan, because it just all the bargain hunters are going to come out, and it's going to waste everybody's time.
That's right. Don't the lenders have an obligation to sell at market value, less a certain discount as time goes on? Is
No,
that true?
there's no certain discount. They have to sell it at market value.
Oh, so they can just hang on.
That's right. Now, after if it's listed at fair market value for a month, 2 months, 3 months, then it's really not fair market value anymore.
Ah.
So the market, as in any listing where an owner wants to sell,
Mm-hmm.
the property listing price has to be dropped until you get some activity. But there's no formula of market value less 10%. No such animal.
Gotcha. So this leads me into my second question in terms of a property. Let's talk about liens registered on title. What are the different types of encumbrances that can be registered against a property in any respect here in Ontario?
Well, of course, there's an ordinary mortgage.
Mm-hmm.
There's a construction lien for payment of renovation costs. There's a court order to say this property can't be sold because there's a court action against it. We call that a certificate of pending litigation. There's a judgment filed with the office of the sheriff that appears on title. There's matrimonial claims where one spouse says, I claim half of this property, even though it's in the other spouse's name. I claim half of it as my matrimonial home, and she or he can't sell it without paying me off. So anything under a court order will be capable of being registered on title.
Interesting. In your experience, have you registered all of these types of liens in the past?
Yep.
Yeah.
I registered a lien 4 or 5 years ago. There was a religious building used by this community for prayers and for studying. And there were two groups of claimants. One said, we're running this religious organization. The other said, we're running this religious organization. And one of the parties came to me and says, we want to put what's called a caution on the title, saying that the other party, the other group of people, don't have the right to sell the property, and we do. So I put a caution on title. Mm-hmm. My clients then got sued for blocking the title. That went on for about 3 or 4 years, and then the claimants dropped the claim because they didn't have any right to do it. So a lot of money wasted, but there's still no court order on who actually owns the property.
Wow. What about something like a joint venture agreement? Let's say two people partner up to buy a house or a building, and one partner says, you know what, I'd like to register this agreement on title to prevent the other partner, who may be on title, from selling. Is that an option?
It may be an option, but I would not recommend it. First of all, I don't think it's a proper document to be registered on title. Secondly, it exposes the private relationship between the parties to public display. That any document registered on title is a matter of public record. And I don't think you want to know that Ryan and John Brown are sharing it 60-40 or 50-50 and that Ryan is getting a management fee. I don't think it's any of the public's business what the private relationship is.
What would a better way be to execute that or to do something similar?
There's not very many ways that I would recommend putting. It's really a trust declaration. It says, I hold the property in trust for you. Not really many ways to do it. And also it may trigger land transfer tax if there's a deemed conveyance. You were interested in options to purchase.
Yeah.
Option to purchase triggers land transfer tax.
Hmm.
And you may not want a member of the public to whom you're about to sell the property for X dollars to know that you sold somebody else the option to buy it at 0.75x, so you know what the profit is. So I really don't recommend registering joint venture agreements on title. I'm not sure that you can in a way that the land registry office will allow you to get away with it.
Interesting. So that takes us to the next question, and I want to put the options thing on hold for a sec because I'm really interested in that, how they work and why they work. But just in terms of how title is actually registered in Ontario, how is that done?
Well, it used to be that back in the days when we used pens, uh, that the seller's lawyer would show up at the registry office with a document called a transfer or a deed, which was signed and witnessed in ink with an affidavit that it had been properly executed. And he or she would show up at the registry office, get a big fat check from the buyer's lawyer, take the document up to the counter, it would be stamped, and that's when the title transfer was registered. That was the paper version.
Hmm.
For the last 25 or so years, we've had an electronic version in what's called the Taranet or TerraView land registration system, where all those documents are prepared, but they're signed electronically. So as the seller's lawyer, I will prepare an authorization for my client to sell the property. It's a deed with an authorization on it, but it's electronic. It doesn't necessarily exist in paper anymore.
Gotcha.
The lawyer will then have his client sign in ink to authorize, or by DocuSign to authorize title transfer to take place. The electronic document will be sent on an internal system to the lawyer for the buyer who can look at it and approve it. It will be signed for completeness by both sides, but not for release. When the lawyer for the buyer sends the money to the lawyer for the lawyer for the seller then goes into the land registration system and clicks release, which authorizes the buyer's lawyer to register it electronically. Was that too complicated?
That's perfect. Some of these inner details, a lot of people never get a chance to hear or understand or even speak to somebody about. So your detailed responses are fantastic.
So in between, while all this is happening with the electronic back and forth, the keys are on a lockbox, but the buyer's lawyer doesn't get the code. And the
Mm-hmm.
money may be sent to the seller's lawyer's trust account, but it's frozen by agreement between the parties. And that agreement says, you've got the money from my client, but I can only allow you to release it when the deed is registered. So the instant the deed is registered electronically, the buyer's lawyer phones the seller's lawyer or emails and says, we are registered, you are authorized to release the money. And the seller's lawyer says, okay, you are now authorized to release the code to the lockbox to your buyers. Thank you for cooperating. Everybody's happy. The seller goes and picks up the keys, and the buyer goes and picks up the keys. The lawyer for the seller calls his client and says, we're closed. I'm going to pay off the mortgage, and with the rest of the money, I'm going to send it to you by wiring it to you or depositing it into your bank account electronically.
Excellent.
A lot of stuff goes on in the background that people don't hear about.
Absolutely. That's the technical side for sure. On the topic of land title, so what would the difference be, knowing that we've transferred from land registry to land titles or vice versa? What's the difference between qualified, certified, and absolute title?
Okay, so back in the 1790s, deeds were written on sheepskin. They were signed with a quill pen, and they were literally delivered to the buyer's lawyer at the registry office or outside the registry office. That was the registry system. And in order for the buyer to make sure they had good title, the buyer's lawyer would have to go back and do a history of the chain of ownership for the last 40 years to satisfy himself or herself that the ownership of the land was properly sold from A to B to C to D to E for the last 40 years. That's the registry system. And it
Mhm.
was up to the buyer's lawyer to certify ownership. Back in 1880, a guy named Torrens in Australia invented a system where the government actually takes over the ownership, and when the property is sold, the seller's deed gets ruled out from the abstract or the book that records ownership, and the government says, okay, now new owner is the owner, and we guarantee it. So that's called land titles. In the last few years, the government has been, so any property that was first conveyed after about 1880 in Ontario was first conveyed is on the land title system, and the government guarantees those titles.
Hmm.
But most of the land in Ontario, particularly southern and central Ontario, is in the old registry system. And over the last 10 or 15 years, the government has been converting that ownership to the land title system. So there's land, the 1880 and on land is called land titles absolute. So that's where the government says, you're the owner, period, nobody else has any rights. When the registry properties were transferred to land titles, the description is land titles qualified, which means the government's guaranteeing good title except for certain things. And those certain things may be, for example, squatters' rights. We call it adverse possession. So the government's
Yes.
going to say, well, you've got good paper title, but we don't know what's there on the ground. So we're going to give you qualified land titles, which means we're accepting certain things out of our guarantee of title. And that one of them is, the easiest to describe it is squatters' rights. So the government doesn't know if you've built a house on your neighbor's property. And if it's been there for 10 years and certain conditions have been met, the owner who built the house on his neighbor's property actually owns the land underneath it. So we have registry, land titles qualified, land titles absolute.
Interesting. And can't you apply, if you apply for a condo certificate now, or a certificate of condominium, something like this, plan of subdivision, one of the two, you can apply to get absolute title. Is that correct?
Yeah, you can apply to convert the property from land titles qualified to land titles absolute. And there's a whole bunch of stuff that you have to provide the government. And if that's provided, then the land becomes land titles qualified. Sorry, absolute. And it's good if there's a dispute over fences or boundaries or squatters' rights, then land titles absolute will wipe out all those claims.
Interesting. Just a quick break mid-episode here. Thanks for tuning into the podcast. Don't forget to sign up to the book, thehighestandbestuse.com. You can find it on all the major platforms, Amazon chapters, Barnes & Noble. You can get the direct links at thehighestandbestuse.com. Now, back to the episode. Let's talk about adverse possession for a sec. This wasn't in the script, but you know what? What the heck? We're here. So elaborate on adverse possession. What does it mean and how does it work?
Two people own a driveway. The property line for the deed goes right down the middle. But the guy on the left has never used it in the last 40 years, and the guy on the right has fenced it off, and he says, it's mine. I've had exclusive ownership, exclusive use of this driveway. Nobody has bothered to use it. It's been fenced off, and it's in my possession. Mm-hmm. And so he will say, I claim adverse possession, squatters' rights. And if he meets certain tests, the court will award it to, there's no wicket at City Hall, but the court will award on a contest, will award the disputed land to the claimant if he has had exclusive, open, continuous use of that disputed property and without the permission of the deeded landowner for a period of 10 years prior to around 1990-2000, which is the day that most registry properties in Ontario were converted from registry to land titles. So if you meet those tests and you go to court, the court will award you ownership of the disputed land. Happens all the time. I do a lot of this stuff. People go crazy for 6 inches or 12 inches of land. They build fences where they're not supposed to, and then it winds up in court. Fence disputes are a big issue in my practice. It's just people, no land is worth more than the land your neighbor has tried to steal from you.
What happens after the year 2000 with some of these adverse possessions claims?
Well, the clock stopped running. That 10-year clock stopped running on the day that the title was converted by the government from registry to land titles qualified. So if you have 10 years of exclusive, open, notorious, continuous possession for 10 years prior to the date the government converted it to land titles qualified, then you can get it. But after that time, if you have 9 years and 364 days, and then the government converted it, you're out of luck.
The clock starts again?
No, the clock stops running. That's the end of it. You don't get your 10 years. You have to have 10 years.
Mm-hmm. So after 2000, would you have to wait until theoretically 2010 to make a claim?
No. After the clock stops running,
it's just done. There's no more adverse possession opportunities.
The clock is pulled out. Clock is pulled out of the wall, unplugged. So if you build a garage in your neighbor's backyard today, you'll never get adverse possession, no matter how many decades it's sitting there.
Really?
Yeah.
Wow. Gosh, what does an adverse possession case cost? Like how do you even prove this? Photos? What?
You get neighbors to prove it. You get the children of the deceased owner. You get photographs, aerial photographs, photographs taken by municipal authorities for road widening purposes. There's all kinds of evidence. And I've seen affidavits from neighbors' kids, from neighbors' grandchildren. Oh yeah, we used to play in the backyard when I was 6 years old. Here's a picture of us playing in the pool in the backyard. There's all kinds of evidence. But if everybody's gone or disappeared, there may not be any evidence.
Huh. Wow. What happens if somebody transfers title? Like if there's a sale, does it have to be 10 years of continuous ownership or no?
The adverse possession rights are related to time, the 10 years, not related to how many different owners there are. So if there are a succession of owners, you're going to have to get affidavits and testimony from a chain of different people over the 10-year period.
Very interesting. Options to purchase. Let's jump into that. So what is an option and what does it mean for a potential buyer or seller?
Well, let's say I have a piece of land and it's at the corner of Yonge and Finch, and I don't want to buy it if I can't develop it. If I can't put up a 20-story condo, I don't want this property. So I go to the owner and I say, I want to buy your land, but only if I can get it rezoned. And the owner says, well, I'm not going to let you play around with it at my expense. So here's what I'll do. I'll let you take an option to buy this land. So I'll sell you the right to buy it. And that right will go for 1 year, 2 years while you do your due diligence with the municipality, see if you can get it rezoned. But if you can't get it rezoned, you still have to pay me my option fee up front. So if it doesn't get rezoned, the buyer says, okay, I don't want it. The seller pockets his fee, his option fee of $50,000, $100,000, $500,000, and he walks away with that money and still owns the land. If the buyer says, I got it rezoned, I got a permit to build a 20-story condo, I want to go through with closing. So the seller says, okay, I gave you an option, I'll close the deal. And that's the simplest way I can explain it. It's an option. It's the right to buy a piece of land, but over a period of longer than, let's say, 30, 60 days. In a normal agreement of purchase and sale of a house, it'll be, let's say, the buyer says, I'll pay you $1 million for your house, but it's conditional on me getting financing. So it's a conditional deal. In a way, that too is an option. So if the seller, if the buyer says, okay, I got my mortgage, now I'll waive the condition. So he's waived his option to get out of the deal and he makes it firm.
Now, how would those differ? Because one has land transfer tax attributed to it, and one is a walkaway where you could say, "Nah, didn't get my financing, I'm out."
Land transfer tax may be applicable in certain circumstances, but just to register the option, there's no land transfer tax.
Really? Oh, can you elaborate on that a little bit?
Well, land transfer tax applies when ownership of the property changes hands.
Mm-hmm.
So when you just pay an option of $10,000 or $50,000, I'm not sure there may be land transfer tax on the option fee. I don't think so, but there may be land transfer tax on that, but the ownership has never changed hands.
Understood. And how would somebody write an option up?
Well, there's forms. There's Toronto Real Estate Board forms, Ontario Real Estate Association option to purchase forms. Mm-hmm. But because most of these are commercial deals, they're usually done on agreements prepared by the lawyers, which are 10 times longer than the printed form.
How many times have you been in an option situation over the 50 years plus?
It happens. It's not extremely popular, but it does happen in commercial situations, in development situations, in redevelopment, in rezoning.
Gotcha. I want to skip ahead to air rights. So we had chatted a little bit about air rights. What are air rights and how do they affect a buyer or a seller?
Down the street from my office is St. James Cathedral. It's been there for, 150 years. It's zoned such that on that parcel of land where the cathedral is, the owner of that land may be able to build 10, 20, 30, 40 stories. But the cathedral is never going to tear it down so they can build condos. That's historic. It's never going to change. Mm-hmm. So what happened was the trustees of the Anglican diocese, whatever it's called, decided many years ago to sell their air rights, which were sitting on top of the cathedral, to a developer next door, and they built a gorgeous, very tall condo, which they wouldn't have been able to build unless they got a transfer of the air rights from the cathedral to the adjacent land, and air rights can be transferred within something like 1,000 feet. So you can't take it up to North York. It has to be within the same vicinity. So that's why there's this great big, high-rise condo tower across the road from St. James Cathedral, because they bought the air rights. The same thing has happened on University Avenue near Roy Thompson Hall. When you take a church or other institutional use and sell the air rights.
Roy Thompson Hall, are there air rights above Roy Thompson that have been sold, or do they still own that? Because Roy Thompson, as a venue, is relatively low compared to the surrounding neighbors.
I actually don't know what Roy Thompson Hall did there, but I know that St. Andrew's Church, which is across the road, mm-hmm. sold its air rights to a developer in the immediate vicinity, but I don't know what happened to Roy Thompson Hall.
Yeah, air rights is almost a business in itself.
Yeah, but it's very scarce because it's got a very limited application. There's only very few parcels mm-hmm. that can do that.
Gotcha. Where would air rights be registered? Like, where does somebody say, "Oh yeah, this property still has air rights attributed to it"?
They're not registered on the land title system. They're in the city of Toronto in this case, or other cities' zoning bylaws. So if you look at a zoning map, it'll mm-hmm. say R4, R6, C10, whatever. And when you look at the zoning density allowed in the bylaw, and you compare it to what's sitting on the site, and then you can figure out the air rights. So the bylaw will determine how many times ground floor coverage you can build mm-hmm. going up.
Interesting. So it's a manual type of calculation. You have to say, okay, physically present, this is what it is versus what it could be. Do the math.
Yeah. So, for example, a residential house in the city of Toronto may be zoned R2. That means that a house sitting on that land, and let's say the land is 50 by 150, that's 7,500 square feet. So the house sitting on that land cannot be more than 7,500 square feet. But if it's R3, it can be taller. If it's R.75, it's lower. And it's all determined by the bylaw.
Gotcha. Have you been in these situations before where air rights have been transacted?
I've seen them a few times for developer clients, but it's very specialized and it doesn't happen very often.
Mm-hmm. There was a really unique scenario in New York City where the owners of Union Station, Grand Central Terminal, of Grand Central said, hey, we've got all these air rights up above the train station, but we're not going to build here because we can't take down this beautiful train station. So they sold the air rights and started a trust to actually support the train station and all the historical restoration. Has anything like that ever taken place in Toronto?
It's possible. I've never heard of it, but it's possible.
Yeah.
I don't think so.
Yeah. What is it about air rights that maybe I haven't asked that I wouldn't know?
I think you covered it pretty well, Ryan. I think you did.
Awesome. Easements. Let's break into easements as we wrap up here. So what is an easement and where can they be found?
An easement is also known as a right-of-way. So an easement is, I have the right to cross your property to get to my garage. Okay, it's over the east 20 feet from front to rear, which is 100 feet long. So it'll be registered as an easement to access my garage, which is to the back of my land, which is otherwise cut off from public access. An easement to take my car down the side, an easement to walk down the side, an easement to bring fruits and vegetables down the side of my farm on the neighbor's property. So an easement and a right-of-way is very similar. An easement can also be used for a pipeline. So I may have a property where there's a pipeline under it in parts of Ontario. And to look at the property, you wouldn't know it. But there's an easement for Trans-Canada pipelines. I've also seen subway easements. So you take a look at a piece of land along, let's say, Yonge Street or the Bloor Danforth line, and there may be a part of the subway underneath the property. And so there would be on title a subsurface easement for the TTC, Toronto Transit Commission, to run its trains underneath the property.
Wow, that's a big bone of contention, I think, right now. People saying, I don't want a subway underneath the basement of my residential home. And the government's like, well, you don't own the dirt. So what does that mean?
The government always has a right to expropriate land that it needs.
Yeah.
So let's say the subway is next door, but they're enlarging it or they're doing some renovation work on the electricity or the cables that fund the subway, and they've got to dig under part of your property to access those cables. So they'll expropriate a temporary easement just so that they can do their work and then surrender it afterwards and then pay you for it. But easements are necessary and they're all over the place all the time.
True or false? When somebody owns a piece of land, let's say residential or any piece of land in Ontario, they only own the surface rights, but not necessarily the mineral rights or what's below the dirt.
When the Crown, starting in the 1790s, granted land to settlers, and that land was then eventually developed and now has a house or condo on it, the original Crown grants, that is the grant from Queen Victoria or William IV or whoever, those Crown grants from the Ontario government, given in the name of the British monarch, said, I grant to John Smith, a veteran of the War of 1812, 100 acres up in Barrie or whatever, subject to the right to retain the minerals underneath the land and subject to the right of the government to harvest pine trees. That's typical. Mm-hmm. So in theory, the government could come along in my backyard in Toronto and harvest pine trees from my backyard. They're never going to do it. But they also have the right to any oil or natural gas or gold underneath my land and underneath most of the land in the province of Ontario. So they could dig down a mile or two and then grab any minerals underneath my property. So that's the typical Crown grant limitations. So I own my land down to the center of the earth and up to the sky vertically, but I don't own the minerals underneath my land.
Have you ever done a deal like this in your history where you've applied for a mineral grant or mineral rights or something like
No, but
this?
I've seen land. I had clients in Temiskaming selling land for development for cottages. And the land that they bought and the land that they subsequently sold had what's called surface rights only. In other words, they had the right to build on the surface and upward, and of course the basement of the house or whatever. But digging down, the mineral rights still belong to the government.
Wow.
So it's still very active.
If somebody wanted to look that up and say, does my piece of land have or not have certain rights, where would they go?
Well, they go to the land registry office, and then historically, I believe this is all online, you would pull out the Crown grant, the grant from William IV or George III or Queen Victoria or Edward VII, and those things were all handwritten in ink with a quill pen and with a big red seal in wax on it, and then it'll say Victoria, by the grace of God, grants to this veteran of whatever the Boer War the land up in Temiskaming. And then it'll say, so it's all in the Crown grant, and it will be in beautiful handwritten letters, it'll say, except for the rights to minerals and pine trees.
Wow. Bob, this has been an unbelievable episode. On this side of the microphone, I mean, I can really tell how deeply knowledgeable you are on the subject of real estate. Like, obviously, all of the amazing things that you've done over your career have been exceptional, and all the information you shared today is no different. So, from me to you, thank you very much for being on the show.
It's a pleasure to meet you online and to talk to your followers, and I'm glad you enjoyed it. Maybe we can do it again soon.
I would love to. Where can people reach out to you or find out more about you if they so choose?
www.aaron.ca. And my email is bob@aaron.ca. I'm not going to spell Bob. So I'm on Facebook, I'm on Instagram, but the main thing is my website, aaron.ca, which has like 800 of my Toronto Star columns. And my contact information is bob@aaron.ca.
Beautiful. Bob, thanks again for being here. Thanks again for listening to the Highest and Best Use Real Estate Podcast. I'm your host, Ryan Carr, reminding you that good deals are found, great deals are created. Don't forget to sign up to the book at thehighestandbestuse.com. Like, share, follow, and subscribe, and we will see you on the next episode.